the argument have been captured in the body of the judgment. So I now go straight to the decision of the court. I have carefully and painstakingly considered the processes filed by the parties in this suit, as well as the written and oral submissions of counsel for the parties. The defendants formulated four issues for determinations which were adopted by the claimant and formulated one additional issue, making the issues on which submissions were made by the claimant to five. Having regard to the facts and evidence of the parties, I am of the view that two issues can dispose of this matter. They are: one, whether or not by the facts pleaded and evidence adduced at the trial, the claimant has been able to prove entitlement to any of the relief sought in this suit. Two, whether or not the defendants have by their pleadings and evidence adduced at the trial been able to prove entitlement to any of the relief sought in the counterclaim. I shall start with issue one. The, the reliefs being sought by the claimants are as contained in paragraphs 55, A to E of the amended statement of facts. The law is well settled that the burden of proof is on the claimant, that is to say, he who asserts must to prove what he asserted before the court for him to be entitled to judgment. In the reliefs being sought, which have been reproduced in the earlier part of this judgment, they are of a mixture of declarations and other reliefs. For the declaratory reliefs, they are seeking for declaring of state of affairs as per the law. Therefore, where a claimant seeks declaratory reliefs, the burden is on him for him to prove entitlement to such a declaration, and he has to rely on the strength of his case and not on the weakness of the defense or absence of defense. See the case of Indul versus Wayo. See Odera Investment Company Limited versus EcoBank. This means a claimant who seek declaratory reliefs before a court of law has the onerous duty to prove that he is entitled to the declaration by calling sufficient and credible evidence. He will succeed on the strength of his case and not on the weakness of the defense. In the case of Luca and another versus Saidu, the Court of Appeal emphasized that a claimant who established their claim to the success for, for a claimant to be entitled to declaration must be able to establish his case by satisfying the court that he is indeed entitled to that declaration. The standard of proof in civil cases, including declaratory relief, is generally on the balance of probabilities. However, the nature of the declaration sought can sometimes influence the rigor with which the standard is applied, especially where serious allegations are made. That's why a declaratory relief cannot be granted in the absence of concrete evidence. The Court of Appeal in GTB PLC versus United Capital Trustees Limited has firmly established that a declaratory release cannot be granted without evidence. This underscores the critical role of presenting compelling evidence to substantiate the claim. The evidence presented must be relevant, admissible, and credible. Direct, Directly supports the facts pleaded by the claimant and not contradictory. I shall now focus on the reliefs one after the other to see whether the claim the claimant has been able to establish entitlement to the reliefs. Or reliefs A, which is for declaration that the first defendant had no right whatsoever to compel the claimant to use her original BSc certificate as collateral security for a loan of 400,000 naira granted to her by the first defendant. For the claimant to succeed on relief A, she must adduce sufficient credible evidence to establish that the first defendant had no right to compel employee to deposit his original BSc certificate as collateral security for the loan. The claimant needs to demonstrate the terms of the loans agreement and the nature of the collateral required for granting of such a loan to employee. The vital evidence would include the loan agreement. This document is paramount as it will explicitly state the conditions for granting the loan, including the requirement to deposit the BSc certificate as security or not. The claimant would also need to show that this condition was indeed enforced by the banks in violation of the requirements of collateral policy of the bank. She must also prove or show by evidence that she was compelled to use her original certificate as collateral against the policy of the bank. The claimant has only asserted that it was not in line with the banking practice to use original BSc certificate as collateral, but she did but there is no iota of evidence of the alleged banking practices adduced by the claimant to prove her assertion. She has also not adduced evidence to tender any banking policy or regulation that prohibit use of BSc certificate as collateral security for granting or taking loan from the bank. In the absence of evidence or proof of entitlement to relief A, I hereby decline to make declaration in that respect, as the claimant has failed in the discharge of her duty in the discharge of the honorary duties of proof of entitlement of declaratory reliefs. On relief B, which is for declaration that the first defendant had no right whatsoever to have kept claimant's certificate for 5 months, 2 weeks after she had repaid the loan on such on which the certificate was submitted as collateral. In attempt to prove entitlement to this declaration, the claimant tendered Exhibit CW1D, CW1E, CW1H, CW1I, CWJKL, and CWM. An appraisal of the evidence in this exhibit and the evidence of the parties on this issue will in no doubt establish that the first defendant indeed did not release claimant original BSc certificate when she completed repayment of the loan advanced to her by the first defendant. The first defendant in claiming having rights of lien and blaming the claim the first defendant claim entitlement to right of lien and blaming the claimant for the delay in release of the certificate. I'm not convinced with the shallow positions taken by the first defendant. The moment claimant had completed repayment of her loan, she became entitled to have her BSc certificate returned to her by the first defendant, which was taken by the first defendant as collateral for the loan granted to the claimant, to be returned to her without further delay. It is the duty of the first defendant to return the said collateral for the loan which had been serviced. The first defendant needs not wait for claimant to make a request before returning the said original certificate. It is because the first defendant considered the said original certificate very vital and important security for the loan. That's why it demanded for it as collateral, and the claimant accepted and submitted same for to serve as the collateral. In the circumstances, The said certificate, if the said certificate is not does not have any value, the first defendant would not have even accepted it as collateral. Having accepted it as collateral, the first defendant has a duty to return it after the servicing of the loan by the claimant. Therefore, I am in agreement with the claimant that the first defendant had no right whatsoever to have kept her original BSc certificate beyond the day of repayment of the loan, that is to say 26th day of April 2021, which all the parties agrees that the loan the repayment of the loan was completed. The claimant has proved entitlement to relief B, same is hereby granted as per. I now move to relief C, in which the claimant is claiming the sum of 52,707 naira 60 kobo as her April as her unpaid arrears of unpaid April salary. In proof of this relief, the claimant has testified that she resigned from the services of the first dependent by the letter dated first day of June 2021. The letter of resignation was tendered in evidence and was admitted as XBCW1I. In paragraph 7 of the letter of resignation XBCWI, the claimant stated as follows: I humbly request that my arrears of salary from April 2021 to date and my terminal benefit be paid to me. The claimant has also averred that she was last paid March 2021 salary on 26th day of April 2021 by the first dependent. In support of the assertion, reliance was placed on XBCWU her bank statement of account, which she maintained with the first dependent. The the dependents on their part insisted claimant was was paid was paid was paid was paid April salary and not March salary, and it was with the said April salary that she completed repayment of the loan granted by the first dependent. With this assertion, the dependent has the onus of establishing the claimant's salary was indeed paid in April 2021 and not March 2021, as per XBCWU as asserted by the claimant. The first defendant, apart from mere assertion, has not adduced any concrete evidence or convincing evidence to establish that the claimant was indeed paid in April, was indeed paid her, was paid April salary on April in April. The law is well settled that he who asserts has the burden of proving such assertion. The burden of proof is on the party who alleges affirmative. The burden is on the party that is the defendant in these circumstances that will lead evidence to show that the claimant was indeed paid April salary by the first defendant. See the case of Dakachi of Dare versus Dakachi of Ebwa. See also Instirim versus Instirim. The first defendant did not adduce any evidence showing payment of April salaries to the claimant. Therefore, the first defendant has failed to discharge its burden of proving the positive assertion it made that it has paid claimant April salary in April. In the circumstances, I accept the assertions of the claimant as the true and correct position regarding the payment of salary, and I accepted that the claimant was indeed paid March salary on 26th day of April, as shown by XBCWU, I found, and so on. In their attempt to impugn the claimant's claim of April 2020, claimant's claim of payment of March salary, the dependent by their paragraph 19. No, in an attempt to impugn the claimant's claim of April 2021 salary as being entitled to be paid. The defendants, by paragraph 19 of the amended joint statement of defense, claim claimed that the claimant state managed a collapse and was taken to University of Calabar Medical Center and treated for an unknown ailment. Upon discharge from the hospital, the claimant did not attend work until the day she sent in her resignation to the first defendant through service, through courier service, and never showed to the defendant by and never showed off again in the office. I have scrutinized the evidence of the parties on the issue of arrears of salary. What is clear from the evidence before me is that the claimant fell sick during the working hours in the office and was rushed to the hospital where she was admitted for treatment. See Exhibit CWF1, CWF2, CWF3, and CWR. These exhibits clearly confirmed that the claimant from 10th day of May 2021 to 2nd day of June 2021 was sick, and this is the period when the first defendant admitted receiving claimant's letter of resignation. At the period, the claimant was not in good health condition. The attempt by the defendant to rubbish the claim of sickness by the claimant, as contained in their paragraph 19 of the amended joint statement of claim, is a mere assertion without proof. DW1, who testified, was not a medical doctor for him to be competent to say claimant state managed sickness or she was treated for an unknown ailment. In fact, exhibit CWF1 to 3 and CWR, which were from a well which were from the hospital, clearly shows that the defendant clearly shows that the dependent was not a true the positions of the dependent was not the true position, as all the exhibits shows that they were received by the first dependent in her office, as there is acknowledgement stamp on the exhibit. In the circumstances, I am convinced that the claimant fell sick and was rushed to the hospital, and the claimant was duly informed of her sickness. The law is right that an employee is entitled to wages for period of temporary incapacitation or absence from duty. See the Supreme Court decision in the case of Under Underwaters Engineering Company Limited versus Dubifem. This case is an authority that absence from duty due to no fault of the employee will not amount to breach of regulation or taken as absenteeism from duty capable of depriving the employee entitlement to salary, since the employee cannot be said to have voluntarily absented himself from work. I am satisfied that the evidence before the court and the supported by exhibit referred to shows clearly that the claimant did not voluntarily absented herself from duty. Her absence was as a result of sickness, and her employer, first defendant, was very much aware of the claimant's sickness, but defendant but deliberately trying to claim that the claimant's sickness as unserious. In the circumstances, the claimant did not deliberately refuse to absent herself from work for the period of her sickness, as the defendants want the court to believe. Therefore, the claim, the claim, the claimant in this case is entitled to have her salary, to have her arrears of salaries paid to her. In the circumstances, the claim for April salary succeed, and same is hereby granted. This is also this position was strengthened by the fact that Exhibit CWU clearly shows that salary paid to the claimant on the 26th day of April was March salary and not April salary. The defendants who are claiming that claimant was paid April salaries are the one having the burden to prove such payment. But in the case at hand, the defendant failed to adduce any iota of evidence in proof of payment of April salary to the claimant apart from mere assertion. In the circumstances, the claimant has proved entitlement to arrears of April salary as per exhibits, as per Relief C. Relief C succeed and same is hereby granted. I now move to Relief D, which is for an order directing the first defendant to pay the claimant the sum of 632,491 naira 20 kobo. This claim is predicated on the claimant's resignation from the service of the first defendant after serving for over 5 years as per clause 6.41C of the Management and Personnel Policy Manual of the dependent, which has been tendered in evidence and admitted as Exhibit CWO. According to the claimant, having served for more than 5 years, she is entitled, as per the terms of the agreement, as per the conditions of service, Exhibit CWO, to be paid to be paid 1 month, 1 year salary. In paragraph 44 of the amended statement of facts and paragraph 45 of the amended witness statement on oath, the claimant stated that since she was paid last month, March 2021 salary, her May 2021 salary is the salary given to the first dependent as in lieu of notice. The dependent on their part insisted that it was claimant that did not comply with the management and personnel policy exhibit CWO, as the claimant violated clause 6.41C by not giving the first dependent 1 month notice of resignation or payment of 1 month salary in lieu of notice. The first dependent further stated that the claimant is not entitled to terminal benefit, as terminal benefit is for staff who retired or resigned from with good record, where the contract of service specified. It is to be noted that where contract of service specifies the length of notice to be given or payment of salary in lieu of the length of notice, and the latter option is chosen, as in this case, by clause 641C. The claimant wishing to end her contract of employment with the first dependent must pay 1 month salary in lieu of notice, contemporaneously with her letter of resignation. The court has consistently held that payment in lieu of notice must accompany the letter of termination or resignation or be made promptly thereafter, must be paid promptly without delay. See the case of Chukuma versus Shell Petroleum Nigeria Limited. See also Skybank. The recent case of Skybank versus Adegun, which affirmed that payment in lieu must be made at the time of termination, and in the case at hand, that is at the time of resignation. Any payment not made contemporaneously with the letter of termination or resignation will be invalid and render the said resignation wrongful. The Court of Appeal in the case of Main Street Bank Registrars Limited versus Olubinga further clarifies the effect of salary in lieu of notice made after the alleged termination, reinforce the need for contemporaneous payment. It is clear to me that Exhibit CW1, the letter of resignation, was lucid, very clear, and unambiguous. In it, the claimant unequivocally resigned from the services of the first dependent. I note there was no notice given by the claimant in her resignation. Furthermore, the evidence before the court established that claimant, upon submissions of her letter of resignation, never showed up in the office again. The conduct of the claimant clearly established that her resignation from the service of the first dependent was with immediate effect. Since the claimant leaves the employment of the first dependent immediately without serving the contractual notice period, this would generally constitute a breach of the employment contract. In such circumstances, the employee will be the employer will be entitled to damages for the breach. The law is well settled that letter of resignation takes effect on the date of receipt of the letter by the employer, i.e., letter of resignation takes effect from the date of delivery to the employer. Once a letter of once a letter of resignation is tendered by an employee, the employer has no option than to accept same, while there exists no inherent power in the employer to, to or servant to resign from his employment, as in this case, as the claimant resigned. There is, however, no discretion in the employer to accept same. The kernel of the principles of labor law is that resignation is not amenable or subject to rejection. See the case of Benson versus Onitri. See also Yusufu versus Governor of Edo State. See also Adefemi versus Abegunde. It is tried law. It is tried that none of the parties can be compelled to continue with contract of employment relationship if the parties does not want to continue with the relationship. It is pertinent to point out that even in the unfortunate event where a party to such a relationship decide not to comply with the terms of contract as agreed upon, like in the case at hand, claimant did not give a notice. Court will not order specific performance of such contract insofar as it is not a contract that is closed with statutory labor. See the case of Kado versus CBN. See also Idoniboye Ovu versus NNPC. It is, in any event, the law considers the right to enter and exit from contract of employment as voluntary one. There is free entry and exit from same. From the evidence before the court, it seems the letter of resignation exhibit CW1 was delivered to the first defendant on the second day of June 2021. This means the claimant's resignation from the service of the first defendant took effect from 2nd June 2021, the day the said letter was received by the first defendant. It is also right to know that the employer has no right to reject letter of resignation from, from service once it is delivered. It does not matter whether the employer has accepted or not, as it is not open to an employer to reject letter of resignation by an employee. Thus, a notice of resignation takes effect not from the date the letter conveying the notice was written or the date any purported acceptance of the said letter of resignation, but from the date on which the letter was received by the employer. See Wayek versus Oshinobo. The employee has the right to discontinue with employment as no party in a contract of employment can be enforced on the other. It is a voluntary affair. Any of the parties can call it a quit at any time. The only snag is that such quitting must be in accordance with the terms of the contract between the parties. At any as any deviation from the procedure laid down by the rules will render such resignation wrongful. and entitle the other party to damages. In this case, the main, the main area of disagreement between the parties is on entitlement to terminal benefit. As pointed out earlier, an employee has absolute power to resign from employment. However, there is consequences if such resignation from employment by the employee was to was to be with immediate effect, as in the case at hand. In Waec versus Oshenivo, it was held that a notice of resignation is effective not from the date of the letter or from the date of any purported acceptance, but from the date on which the letter was received by the employer or his agent, and that tendering of a letter of resignation by an employee carries with it the right to leave the service automatically without any benefit, subject to the employer paying any of the indebtedness to his employee, while giving notice of retirement carries with it the right to be paid a pension and gratuity, but it does not confer with the right to withdraw from the service immediately and automatically. See Benson's versus Onitri and Osu versus Fan Limited. See also Esifu versus Governor of Edo State. In the in the case at hand, by the exhibit CW1 letter of resignation, the claimant resigned from the service of the first defendant with effect from second day of June 2021. As the claimant stopped going to work after submissions of the letter of resignation and no notice was given, this means the claimant resigned from the employment. This means the claimant resigned her employment, resigned from the employment of the first defendant with immediate effect. This position was confirmed by the assertion of the claimant in paragraph 44 of the amended statement of facts and paragraph 45 of the amended witness statement on oath, to the effect that her May 2021 salary is the 1 month notice in lieu of notice. I have earlier in this judgment found that the assertion of the claimant cannot serve as payment in lieu of notice, as the purported assertion was not contained in the letter of resignation. This means the claimant's resignation was in violation of clause 641C of the Management Policy and Personnel Manual, exhibit CWO. Therefore, the resignation was wrongful. The resignation of the claimant had automatically ended the claimant's employment with the first defendant with immediate effect. The action of the claimant in resigning from her employment with the defendant in violation of clause 641C has deprived the claimant of the right to claim any benefit apart from earned salaries. The law strikes that resignation with immediate effect by an employee carries with it three effects. One, right to leave the service automatically. Two, employees forfeiture of any benefit. And three, employee paying any indebtedness to the employer. The, justi- the justification for having to allow the resigning employee to leave immediately is the fact that if she thereby forfeits any benefit she may be entitled to, as well as duty to pay off all indebtedness that she may have toward the employer. As such, the forfeiture of benefit inures as contractual consideration for the immediate and automatic repayment of the contractual relationship as per the employment issue. So it cannot be that an employee who resigns with immediate effect is allowed to also benefit from such immediate separation by claiming benefit from the employer. The benefit which the claimant becomes entitled to, as well as a result of resignation with immediate effect, do not include earned salary, because earned salaries is not the same with benefit or entitlement or terminal benefit. This is because benefit is an advantage, privilege, profit, or gain, which means payment or gift by the employer. See also the case of Dr. Dave Nwabo versus Oil Flow Services Limited. A reported decision of this court in suit number NICN stroke CA stroke 552 stroke 2015 delivered on the 10th of July 2017. Let me reiterate at this at the risk of repetition, that the right to leave employment with immediately in the case of resignation does not extend to case of notice of retirement, CYX versus Oshinobu, where it was held that the giving of notice of retirement carries with it the right to be paid a pension and gratuity, but does not confer the right to withdraw from service immediately and automatically. From all I have been saying above, the claimants resigning her employment with immediate effect has deprived her of any course of action regarding any benefit from the defendant. The claimant has, by her choosing to or decided to leave the services of the defendant with immediate effect as per Exhibit CWO has unwittingly shot herself at the foot, thereby injuring herself without any succor. The resolution of the effect of resignation with immediate effect has deprived the claimant entitlement to terminal benefit as provided for in clause 641C, because no notice of payment in lieu of notice was given by the claimant. For the claimant to lawfully disengage, she has to give 1 month notice. She has to give 1 month notice or payment of notice or payment of 1 month salary in lieu of notice to the first dependent. From the evidence of the parties, the claimant did not give 1 month notice or as required by regulation. She only asserted in her pleading and witness statement on oath that the first dependent should take her May salary as her salary in lieu of notice. This is a belated payment of salary in lieu of notice. However, going by the requirements of the law on payment in lieu, which has to be contemporaneous with the letter of resignation, the claimant has not paid 1 month salary in lieu of notice. See Chukuma versus SPDC Sufra. This means claimant is in breach of clause 6.4, 1 and C of the management policy and personnel manual. In law, once claimant has not properly resigned, she cannot lay claim to any terminal benefit apart from an arrears of salary, which I had already granted as per Relief C. In the circumstances of this case, claimant has lost and forfeited her entitlement to terminal benefit for her failure to adhere to clause 6.1 of the management and personnel policy of the dependent. Therefore, relief D fail, same is hereby dismissed. I now turn to relief E, which is for the sum of 30 million naira as general damages to the claimant. In law, general damages are awarded for natural and probable consequences of dependent's wrongful act, while the quantum is at the discretion of the court. The employee must provide a factual basis for the claim for the claim. In this case, the claimant has succeeded or retention of her has, has succeeded on her claim on retention of her certificate and non-payment of April salary. The claimant's oral testimony detailing the specific inconvenience, distress, or opportunities lost due to the dependent's unlawful retention of her original BSc certificate for 5 months is very crucial in assessing general damages. This could include inability to apply for a new job requiring the original certificate, inability to pursue further education, or general emotional distress and anxiety caused by the deprivation of a vital personal document. The claimant has not told this court of any employment opportunity she has missed due to non-release of her original certificate or that she could not further her education due to non-release of the certificate. But she has. But she has stated that she was distressed by the refusal to release the original certificate, and she also stated difficulty faced due to non-timely payment of her salaries. In the circumstances taking into consideration the above stated factors, I grant the sum of 1 million naira damages to the claimant for the distress caused for the discomfort in not releasing her certificate at the certificate of certificate after completing repayment of the loan and non-timely release of her salary.
My lord, I can't hear you, my lord.
Yes, I'm sorry. I was I missed something, so I'm trying to type it.
Okay, my lord. Okay, my lord.
Yes, the defendants have made heavy weather on claimant's refusal to honor query issued to her by the first defendant. The law is tried. Once employee has resigned his employment, even if it is wrongful, the, the, the employer has lost the right to discipline that employee. The claimant has the claimant, by refusing to answer the query issued to her by the claimant after she has left service, has not committed any wrong. When such query was issued after the claimant had left the services of the defendant does not have control over employee once an employee has left the services. More particularly when the matter in which the claimant was being accused, when the money the claimant was being accused of embezzling had been reported to the police for investigation. And in fact, investigation is still ongoing as per the evidence before the court. In the circumstances, I refrain from making further comment of the issue of the matter already before the police for investigation. The decision on counterclaim. The second issue for determination is whether the dependent counterclaimants approve their counterclaim to be entitled to the relief sought. The counterclaim of the defendants has been reproduced in the earlier part of this judgment. In the counterclaim, the defendants counterclaimants are seeking for payment of the sum of 4 million naira as general damages against the claimant defendant to the counterclaim in favor of the first defendant counterclaimant for painting the first defendant counterclaimant in bad light before her loan customers when the claimant dependent to counterclaim received their loan repayment without lodging it in the loan accounts, in the customer's loan account. The sum of 280,000, 200,000, 200 naira only was said to have been amount received by the claimant dependent to counterclaim for and on behalf of the first dependent counterclaimer, but was not lodged in the accounts of the customers. And 1 million naira 1 million naira in favor of second dependent counterclaimant for being sued personally by the claimant dependent to counterclaim without justification. The law is right that a counterclaim is a separate and independent suit of its own. Therefore, just as claimant has the burden of proving his case to be entitled to grant of same, the dependent counterclaimant also must adduce sufficient cogent and credible evidence in support of the counterclaim. See the case of UAC Nigeria PLC versus Eunice Akinyele. On relief one of the counterclaim, there is no evidence adduced by the second defend by the first defendant to establish that the claimant painted the first claimant in bad light before her customers, whom claimant defendant to counterclaim was said to have received their loan repayment without lodging it in the customer's loans accounts. As none of the customers who took the loan from the first defendant was called as a witness to testify how claimants painted the first defendant counterclaimant in bad light to them. The reliefs, these reliefs failed due to lack of proof and same is hereby refused and dismissed. Or relief two of the counterclaim, the pleadings and evidence of the defendants gave different figures as the money collected by the claimant, dependent, counter-claimant from different customers. The figures which the claimant, dependent to counter-claim, was said to have paid into the accounts of the customers also differs, though on the figure said to have been paid amount same figure, not to have been paid amount to the same figure. The different figures said to have been collected and paid into the court, into the into the accounts of the customers, having been having been found to be different, shows shows that something is amiss. It also shows that the dependent counterclaimant do not know the exact amount collected by the claimant from the defendants from the customers of the first defendant. The differences in the amount of money said to have been collected by the claimant is contradiction in the evidence of the defendant, and it shows how inconsistent the dependent counterclaimant has been in marshalling out his case before the court. The law expects a party to be consistent in his evidence and presentation before the court, which is not the case in this case. Another issue that raised doubt about the case of the defendants is the fact that the loan was said to have been given to groups, and the documents produced in proof of collection and alleged non-payment were for individuals. This has also raised doubt as to the claim of the claimant. The claimant had insisted that the individual's accounts are not the same with the group's accounts, and that the individual's accounts have maintained their account with the dependent, and she also assisted them to pay their money. In the circumstances and in view of the inconsistency in the evidence of the defendant regarding the actual amount advanced and the actual amount collected by the claimant, and to the exact whether it is to the individual or to the group that the amount was advanced or collected by the claimant, this court cannot accede to grant the relief of the first defendant. It is also important to point out that since the allegation regarding the 280,200 naira amount to a crime, it would be better to allow the investigation to be conducted by the law enforcement agency in charge of investigation, and at the end, the claimant, defendant to counterclaim, prosecuted for the alleged offense before a court of competent jurisdiction. The parties are at idem that the matter had been reported to the police, and the police have already begun investigation. In view of all this, relief two failed, same is hereby refused and dismissed. I now turn to relief three of the counterclaim, which is for 1 million naira in favor of the second defendant counterclaimant for being sued personally without justification. The second defendant has not appeared before the court to testify, and the claimants in paragraph and the claimants in her amended statement of facts and witness statement of oath has averred that she, the second defendant counterclaimant, that she came to the second defendant counterclaimant, knelt down, begged for her release of her original certificate, but the second defendant, who is the alpha and omega of the first defendant and the directing mind of the first defendant, refused to release the said certificate. It is pertinent to note that the abandonment of the claimant defendant to the counter claimant on meeting the and kneeling down before the second defendant counter claimant can only be answered by the second defendant himself and not DW1, who was not present when the said incident took place. In view of the lack of evidence in proof of relief of the reliefs in lack of proof of relief 3 by the second defendant, the release failed and same is hereby refused and dismissed. From all I have been saying above, the claimant has succeeded in fact, while the defendant has woefully failed to prove entitlement to counterclaim. In view in view of my finding above, the order of the court is as follows. One, the claimant is entitled to payment of April arrears of April salary in the sum of 52,707 naira. Dependents are hereby ordered to pay the claimant the said sum of unpaid April salary. Two, the defendants unjustifiably refused to release the claimant's original certificate and also delayed the payment of her March salary. This has entitled the claimant to damages, which I assess in the sum of 1 million naira. The counterclaim failed in its entirety as there is no evidence in proof of the said counterclaim, and same is hereby dismissed. I award no cost in this matter parties to bear their respective costs. Judgment is entered accordingly.
As the court pleases.
Yes, Registrar.
Yeah, my lord, we are grateful. Thank you, my lord.
Okay. Yes, the Registrar. Victoria.
Yes, my lord. My lord, I'm
My Lord, may I with humility announce my belated appearance.
I am
Austin
for the defendant. I had difficulty joining this and had to come from back to the court.
It's all right. It's all right. You better go and learn how to use it. Because the world is changing. You can't continue to be in the olden age.
Thank the court for I've got a of it in any other I'm attending. And for the past 27 years, I've been going to different courts. So, my Lord, I must commend the court for the industry.
It's all right.
For the diligence. Thank you, my Lord.
You are welcome.
Even that did not win 100%, but then I can appreciate the work put in this judgment.
It's all right.
Thank you, my Lord.
You are welcome. Yes, any other matter?
No, my lord, that's all for today, my lord.
Okay, thank you very much. We have come to the end of today's proceeding.
Thank you, my lord.
Thank you, my lord.
Okay, you are welcome.
So the woman did not get that entitlement that brought her to court. He didn't get it. But it's just for the detention of her certificate.
The only thing that would have given her victory if she had shown that she had
given notice. But
we
argued that she never gave that notice. And she agreed that she didn't give it.
Never. It shows clearly.
No, thank you so much. At least
You've done a great work.
it was not a small work because we couldn't get enough of our witnesses to come and prove our counter claim. You understand? None of our witnesses, not even one. We changed witnesses again, and we couldn't bring anybody. I thank God. Yes.
If not this kind of money that has come out,
30 million.
it would have been difficult, and my Lord would have granted it.
You will have granted it. 30 million. Uh-huh.
My Lord would have granted it. There is no two ways about it.
Yes. Where, my friend? We are not there when I give the state high court.
Okay, sir.
I have this thing before. This is.
We'll talk now. I will
make the judgment available. Okay. Because I know they will need the. Let me see whether I carry